for the gala dinner, please take your seats. Thank you very much. Dear participants of the conference, welcome to the gala dinner of the 8th Biennial Conference of the European Society for Comparative Legal History. The first part of today's event is the keynote presentation of Professor Stefan Vogenauer, Director of Max Planck Institute for Legal History and Legal Theory. It is my honor to introduce the host of the keynote presentation, Professor Kentaro Matsubara from University of Tokyo. And now I would like to give the word to him.
Ladies and gentlemen, thank you very much. It is my pleasure and privilege to be able to introduce to you Professor Stefan Vogenauer, who is going to speak to us about back to the European past in building the future of Asian contract laws. Professor Vogenauer, as you know, is director of the Max Planck Institute for Legal History and Legal Theory in Frankfurt, of course. And just a little, and head of department of European and Comparative Legal History there. I am also told that he has recently taken up the post of heading all Max Planck Institute studies in the humanities and social sciences. So that is an even higher position than I had originally anticipated that I had to introduce. Now, a true European, Professor Vogenauer was educated at the universities of Kiel and Paris and Oxford. And after completing his professional training and conducting research in Germany, he was appointed Professor of Comparative Law at the University of Oxford at the ridiculously young age of 34. And this is a position that he held until 2015, when he took up the directorship at the Max Planck Institute. After being elected, well, not after, okay, as well as being elected Fellow of the British Academy, in 2012, he was awarded the Humboldt Award for lifetime achievement in research. I met Professor Vogenauer, we calculated that it was 9 years ago in 2016, and then he was telling me that he was embarking on this new project on Asian contract laws. And today I am looking forward very much to hearing how that project has evolved but at least we now know that it is a 6-volume series, a substantial series published by the Oxford University Press. 4 volumes have been published so far, and the 5th volume is due to be out this year, and the 6th volume next year, as I was being told. But without further ado, I would like to now hear really what this project has evolved into, and what the past, or what the travelling into the past of European legal history brings to the future of the art contracts laws in Asia. So please, Professor Vogenauer.
Well, good evening. Thank you very much, dear Chair, for a very kind introduction. The Rector of the University is here, Professor Rovo, the Chancellor of the University is here, Dr. Fendler, the Dean of the Law Faculty is here, Professor Gurek. I'm very humbled. The President of the Society is here, Matt Dyson, and of course the Chief Organizer of this conference, Norbert Varga. Welcome to you all, and welcome to all members of the Society. I'm truly delighted and honored to be here. And I'm here with a sense of guilt and shame. As you just heard, I'm heading a department that is called Department for European and Comparative Legal History, and yet I have never been to a meeting of this society. I will atone by giving a lecture tonight. I feel I should have made it before. It wouldn't have been that far from Frankfurt to Augsburg, for example, but there was always something intervening, and I'm all the more grateful for the kind honor and introduction to speak to you tonight. On a more informal note, this feels still, although I've never attended the conference, like a family reunion. I'm delighted to see so many familiar faces. It's not that I feel in the company of strangers, so I hope we will spend a good hour together. It is an hour, and if I were the President of the United States, I would feel like, I would say perhaps, this is a lecture like the world has never seen. It's the bigliest lecture ever, because it's in a very special setting. We have the grand hall in an even grander building, but we're also sitting slightly uncomfortably close to the buffet at the end of a very long day, where most of us will be tired from the sessions, maybe hungry, are certainly thirsty, and I'm now between you and the dinner, and I apologize for that in advance. I asked Professor Varga whether he would like perhaps a slightly more informal after-dinner speech, a pre-after-dinner speech in the English style. I mean, the President of the Society knows this very well. I would then be able to get away with a few mediocre jokes like, how many comparative legal historians does it take to change a light bulb? Or I would then culminate with praise of the institution, in this case, the Society, telling you all how great it is. But I was firmly told that this is a proper lecture. It's meant to be finishing at 8 p.m. And it will not have PowerPoint, because that's a little bit difficult in the session. And quite conveniently for me, there will be no Q&A. So I can say whatever I want, and you will not get any opportunity to criticize me or challenge me. It's great to be in Szeged, and I have to say, it's great to be back in Szeged. I was here once before. It was in August 1989. I had just finished my mandatory army service, and I was about to become a student of law at the University of Kiel. In those days, I was not only much younger, I was also much fitter, I have to confess, and I used to go cycling every summer. And in this summer, we had planned, I think told you that just recently, we had planned to go to the Baltic states. But that got a little bit dangerous. 1989 was not a good time to travel to the Baltic states. So we very spontaneously decided to go somewhere else, behind the Iron Curtain, but not so really behind the Iron Curtain. So we went to Hungary. And we arrived in early August, and these were the days where we didn't have internet, we didn't have access to newspapers, and we were just cycling for 3 weeks. And we were starting in Budapest, we're going around the Tatra Mountains, we're going through the Great Plains, and we're actually coming to Szeged at some stage, which was, as it is today, a very beautiful place. And by the time we finished our tour, Europe had changed. On the 19th of August that year, that was the day of the so-called Pan-European Picnic, which was a mass flight of 600 to 700 East Germans who had used an informal celebration at the border close to Sopron to escape. And we didn't know about this. And I'm just mentioning this because for us as historians, it's really sometimes important to keep in mind that things can change. They can change overnight, and they can change certainly in the space of a generation. Today, I came to Hungary. I didn't have to show my ID. Sorry, Matt, you did. Hungary is a member state of the EU, is in the NATO, and if you disembark the plane at the airport, you go through these, I don't know how they're called, fingers, into the airport, and it says Hungary is the country of Audi, which I found very, very strange. So this was inconceivable in 1989. It was just inconceivable. And I think that's important to think about. Now, let's move to Asia. I would like to take you away from Europe to Asia, but not really away from Europe to Asia. Because we will approach Asia through European eyes, and I will try to do that without exoticizing, without orientalizing, just trying to give an account, a comparative account of Asian laws that is firmly grounded in history. And as Professor Matsubaro has mentioned, I'm reporting some results of a major comparative project that is meant to culminate in 6 volumes overall. 4 have just been published on Asian contract laws. Well, perhaps the title is a little bit overambitious because Asia is a big continent and we're only covering 13 Asian jurisdictions. But within those, we cover most of the South, Southeast, and East Asian countries, 13 overall. And if you take them together, they make up for roughly half of the world's population, ranging from the most populous countries on Earth, India and China, down to tiny places in terms of population like Singapore, with just 4 million, but including big countries in terms of population with more than 100 million inhabitants, Vietnam, the Philippines, Indonesia. And these include the so-called Asian tigers, countries that for the past 50 years have made the transition from so-called developing nations to serious international economic competitors. So this is an important world region to look at. And contract law is, of course, the most important, I would say that, the most important field of private law to study. But what do we actually know in what I would call the West, the non-Asian language-speaking part of the world? What do we actually know about Asian contract laws? And when I started on this project, I knew basically nothing. And now I'm in the typical situation of someone who has studied a lot intensely, I know even better and even more how little I know. These Asian countries are also important for us because they're not just economic competitors, because as we see dramatically at the moment, they will be the center of the world economy and world power in the very foreseeable future. There was in 2020 a graph in the Financial Times that basically tracked the proportion of the Asian economies in the world's overall GDP. And the tipping point was predicted to be 2022, that the Asian economies collectively would contribute more to the world's GDP than all the other regions of the world together. That tipping point was slightly deferred because of the pandemic, but it will happen. So we must know what's going on in Asia. And when we look around in the Asian contract laws, the good news is that much of it looks alien, strange, foreign, but much of it also looks incredibly familiar. And this is the balance that we try to strike with this project to show what is familiar, what can be understood relatively easily by European or Western lawyers, and what is very unfamiliar and needs further exploration. The project, as I said, has 6 volumes, and it's a very traditional comparative project. Many of my comparatist friends would say it's actually old-fashioned. We do something that has gone out of fashion. We do country reports by people from the various jurisdictions involved, and then at the end of each volume, we have a concluding comparative summary. The country reports normally deal with one particular topic of contract law, like formation of contract, remedies in contract law, invalidity, contracts for the benefit of third parties, and so on. So we go through these areas like we would through a textbook on national contract laws, and we then always have country reports telling us what, for example, is the mainland Chinese law on contracts for the benefit of third parties, what is the law of the Philippines on contracts for the benefit of third parties, and so on. So what do we try to achieve with this project? First of all, it's an exercise in providing information. We just want to map out these Asian contract laws for an audience to whom they have so far been inaccessible. But then, of course, we want to engage, secondly, in a comparison, and thirdly, and this is perhaps the part of the project that is the most relevant for this audience, we want to trace the origins of these Asian contract laws, and so you can see we do comparative legal history. I would like to exemplify this on 2 levels tonight, because what we're going to talk about mostly are legal transfers. And I would like to cover those 2 levels. The first that I call the level of a macro transfer, and the second where I want to look at a few examples of micro transfers of individual rules or doctrines. So let's start with the macro transfers. These are actually generally familiar stories. If you study a law in Asia, that's perhaps what you would study in your session 101 on, I don't know, Japanese law or Korean law, where you learn about the origin of the legal system as such. You see and you learn that many of the private laws of these 13 countries are influenced either by the common law tradition, including, in one case, the common law as we find it in the United States, that in private law is pretty far removed from English law. We also see that many of the private laws were influenced by the German or Germanic tradition, others by the Romanistic or French tradition, and you still find vestiges of the socialist tradition that has even been exterminated from comparative law textbooks today because it is said not to exist any longer, but these traditions live on, maybe sometimes like zombies. They walk through the legal landscape, although socialism has died. So most of these transfers are legacies, or you might say all of these transfers are legacies of colonialism. Professor Matsubaru, when we chatted earlier, said, well, we in Japan, we chose the German model. But I've met Japanese colleagues who are adamant to say, well, it wasn't a real choice. We had the unequal treaties that told us that we had to modernize our law. And one way of doing that, like today, one way of pleasing the World Bank is simply adopting US insolvency law. One way of showing that we were modern at the time was to adopt the German model. So at least indirectly, this was also a legacy, or this adoption is also a legacy of colonialism or of Western power play in the late 19th century. So at the macro level, what do we see in those 13 jurisdictions that we look at? We cover 5 that you could count within the common law family or tradition. 2 of them are very small, Hong Kong and Singapore, and they have private laws that are deliberately designed to resemble English law as much as possible. So that's a post-colonial twist that after independence or semi-independence, the governments chose to remain as faithful as possible to English law because that was a good argument to attract investors, banks, to say we have a legal system that is as good as English law. So Singaporean lawyers would sometimes say our private law is a carbon copy of English law, which is actually an exaggeration, but there is a lot of truth in it. Now today we of course see how Hong Kong law is gradually changing under the influence of mainland China, but contract law so far has not been affected by this. But perhaps more interestingly, what we see in South and Southeast Asia are a number of common law jurisdictions that can legitimately call common law systems, but deviate a lot from English contract law because they're all based on Indian law. India adopted in 1872 the Indian Contract Act, which was based on a more or less academic understanding of what English law was at the time. And this was introduced in all the parts of the Raj of the Vice Kingdom in India, and that included today's Myanmar, it included today's Pakistan, it included today's Bangladesh. We're not covering, unfortunately, Bangladesh and Pakistan. And from these places, it also influenced Malaysia. Malaysia adopted in 1950 the Malaysian Contract Act that was identical, word by word, with the Indian Contract Act 1872. So you have a number of sizable jurisdictions that are firmly common law, although, as I'll try to show also later, we have decided that at least for the purposes of contract law, I shouldn't say we, I have decided for myself, and my co-editor will have to be convinced. My co-editor, I should actually say this, I had this here, but jumped ahead. My co-editor is Mindy Chen-Wishart, who used to be a colleague at Oxford and is now Professor of Excellence in Singapore. And we always have for each volume a co-editor, a third co-editor who comes from one of the Asian jurisdictions that we cover. Hirosono from Japan, Dora Neo from Hong Kong, from Singapore. So we always try to get someone with local knowledge into the editorial team. So I have decided, and I will convince my co-editor, that it makes sense actually, at least for the purposes of contract law, to speak of the Indian legal family. Because what we see if we analyze those contract laws that are based on the Indian Contract Act, they really differ in many regards very strongly from the pure common law that you find in Hong Kong and Singapore. So we have the common law tradition still living on and quite lively in that way in Southeast and South Asia. But we also have a number of jurisdictions that have a Germanic origin, again, at least in the area of private law, and we are only covering contract law. The Japanese Civil Code, as is well known, was adopted in 1896, and it's a general sense of pleasure that German lawyers feel that they can always say there was a previous draft that was based on French law, which was then abolished, and the Japanese rather chose the German model. But that didn't make it easier, because some pockets of French law remained. There's still parts of the Japanese Civil Code that are modeled on the Code Civil, but the vast majority of the rules was taken over from the German Civil Code, but not the German Civil Code as we know it, but the first draft of the German Civil Code that was available in 1896, and that was actually quite strongly reworked between 1892 and 1900, when the final code was adopted. So in this East Asian region, we have a contract law tradition that can be traced back to a draft German code. This was very influential in the region. It migrated to Thailand, where the Civil and Commercial Code of 1925 adopted many of the Japanese rules. In 1926, there was a draft in mainland China that was never enacted, but came then more or less unamended into force in Taiwan as the Taiwanese Civil Code of 1930. And also South Korea adopted a German-style civil code, again based mostly on the Japanese model, in 1960. Mainland China since has moved on and in a way liberated its contract law very strongly from the German influence with a contract law freestanding act in 1999, and then of course the relevant passages of the new civil code in 2021 that are again modeled very closely on the Contract Act of 1999. So it is a very familiar and sometimes unsettling experience if you come as a German private lawyer, for example, to Taiwan. You meet elderly gentlemen who speak fluent German because they wrote their PhD in Germany, who actively follow the German case law, know much more about German law than I do because I'm just a humble legal historian. I don't really know what's going on. So they really see themselves still very much in that tradition. The third tradition, European tradition that you find in Asian contract laws is the French tradition. Where it's perhaps most obvious is the case of Vietnam, which was two French colonies, later protectorates, for quite a few decades in the late 19th and early 20th century. But in Vietnam, we have a strange interplay between a French-style tradition of codification and legal terminology with a socialist law overlay that then has, since the 1990s, a very strong deliberate neoliberal overlay. So what you have is a totally eclectic mix of all sorts of influences and a rapid succession of three major civil codes, 1998, 2005, 2015, so that if you look at the various rules, doctrines, institutions, contract law, you certainly recognize many that are modeled on the French example, but it's pretty different from French law. Perhaps surprisingly, French law lives on much more happily, I don't know whether that's the right word, in Indonesia. How that? Indonesia was a Dutch colony until the 1940s. And in what today is Indonesia, the Dutch introduced the Dutch Civil Code of 1838, which is more or less a tradition of the French Code Civil of 1804. Quite shockingly, they actually enacted it in the Dutch language, and that is still today the only official version of the Indonesian Civil Code. There are, of course, translations into regional and national languages, but they're not official. Although from all that I hear, hardly anyone actually speaks Dutch any longer among the Indonesian lawyers. So at least the rules, and that of course as we all know doesn't mean that the law as such are substantively French. And the third jurisdiction in this area of the world that we would count to the Romanistic tradition are the Philippines. There it's perhaps again an obvious legacy of colonialism, because in 1889, or the Spanish Civil Code of 1889 was introduced by the Spanish colonial government in the Philippines. But then the Philippines were taken over by the Americans, who actually also introduced quite a few American contract law doctrines, and the new so-called New Philippine Civil Code of 1949 blends the Spanish tradition with US-American contract law. So the Philippines, at least in the area of contract law, a true mixed jurisdiction. So where does that leave us? That leaves us with a patchwork of traditions in Asia that on the surface looks like the patchwork we have in Europe. And that is really, really strange, because, I mean, you go to the countries, you speak to the people, you see somehow this is not Europe. So how can it work? How can European laws live on in this very different environment, very different circumstances? And the answer is, of course, by adapting. And this leads me to the second main part of my lecture, when we look at the more granular level, at what I would call micro-transfers, and see what actually are the nuances and the variations of these macro en bloc transfers of contract laws if you look at individual rules, doctrines, and institutions. And I would like to briefly touch on three areas that we've already covered in those volumes: contractual interpretation, the policing of unfair contract terms, and the grounds of invalidity. And don't worry, I don't want to give a very technical lecture. I just want to pick out a few examples where you can see how differently this process of borrowing, adaptation, copying, translating, we all know there's transplanting, of course, we all know the terminology here, which is all good and fine until you look at the detail, at the micro level, and then you see it's so much more varied than most people would assume. So I'll start with the interpretation of contract. Remember, we have a common law tradition, we have a Germanic tradition, and we have a Romanistic tradition. And on the surface, you see, again, many borrowings that look extremely familiar. So if you ask a contract lawyer from Indonesia, tell me something about interpretation of contracts in Indonesia, he will jump up like a French lawyer and say, it's subjective. It's subjective. It's all about the will of the parties. Okay. And then you ask a contract lawyer from Hong Kong and say, tell me something about the interpretation of contracts in Hong Kong. And she will jump up and say, it's objective. It has nothing to do with the will of the parties. It just has to do with the meaning of the words. I think, okay, well, that sounds, again, very common lawyerish, as opposed to the French-style approach in Indonesia. But then you do something that we also did in this very traditional comparative approach, the so-called Trento or common core methodology. We gave a number of hypothetical case scenarios and asked lawyers to resolve them according to their national law. And one of these scenarios is a very famous case from Germany, the so-called shark meat case, where two parties actually use the word shark meat, although they want to transfer or sell, have a contract for the sale of whale meat. And why do they make a mistake? Because they use a Norwegian term, and they both misunderstand that Norwegian term. Now the question is, do we have a contract for the sale of shark meat or whale meat? Do we focus on the words that were used, that are unambiguous here, or do we focus on the intention of the parties? All our Asian jurisdictions come to the same result here. And interestingly, they all use exactly the same tools that the source jurisdictions in Europe would use. The Germanic systems use a doctrine that actually predates the civil code, the Jus Commune doctrine called falsa demonstratio non nocet. So they received, because it's not in the code, they received the German scholarship and the German case law. The Romanistic systems say, well, of course, it's about the will of the parties, because contract is the will of the parties. We don't even talk about these cases in our jurisdiction. It's just what we do. And again, you find that in the Asian jurisdictions. And the common lawyers say, this is not a question of interpretation, this is a question of mistake, because they have a mistaken belief about the meaning of the words. And yeah, we can't resolve this via interpretation, but we have a special doctrine that we call rectification. If it's a written contract, you can sue for the contract being rectified so that it reflects what the parties actually intended. And again, you see that in all these common law jurisdictions. Of course, we don't have a code that transmits this, but the English case law is received. So this is an example where we look at the micro level and we see that this kind of superficial reception that has happened goes down to the very level of the detail of an individual rule. That would also happen if you look at what we often call the aids to interpretation of contracts. So what are the elements, the factors that a judge may look at when interpreting a contract? So the nature of the contract, of course the words of the contract, the purpose of the contract, and now, and here's the alarm bell for the common lawyers, not the negotiation of the contract. That's the one big difference between the English law on contractual interpretation and the French and German law, that the French and Germans would say, of course we look at the negotiations of the contract, because that will tell us something about the context that should influence and inform our process of interpretation. And in England, you have what's called an exclusionary rule. You are not allowed to take those factors into account in the interpretation of contracts. And again, you see that exactly playing out across the three families in Asia. And third example, where you have a very strong similarity, is what you actually do if you have a conflict between various aids of interpretation. If the wording, for example, contradicts the purpose of the contract. These are the most, of course, contested contractual interpretation cases. And there we have some jurisdictions that are strongly literalist, that give precedence to the wording, and we have jurisdictions that are more purposivist or contextualist, and rather say, well, if we can be sure that the wording doesn't reflect what the parties actually intended, then the wording has to give. These are general approaches that are very difficult to pin down even in individual jurisdictions. But again, if we look at how jurisdictions describe themselves, contract laws describe themselves, they would normally place themselves on a spectrum between full literalism and full purposivism and say we're rather in this camp or rather in that camp. And again, you see that mirrored in Asia. The fourth example, where we see a huge congruence with the European source jurisdictions, is the question of what we do to fill gaps in contracts. Again, for German lawyers, there's a huge debate, and they have developed, and again, you don't find it in the code, they have developed a theory of supplementary interpretation, as they call it, which is essentially gap filling. If a case is not provided for in the contract, you fill the gap by having recourse to the context and the purpose. The French do the same, but they don't talk so much about it, because they say it's about the will of the parties anyway, and when we know the will, we can fill the gap. The English say, oh no, we can never fill the gap. That's a real problem, we can't do that by interpretation. But maybe we can imply a term, and then they have a doctrine called implied terms, which has very specific rules and circumstances, and limited, much more limited than in Germany and France, where you can imply it. Now, I'm only saying this because, again, you look at Hong Kong, at Singapore on the one hand, you look at Korea, Taiwan on the other hand, and you can see exactly the kind of mirror image. So, it looks as if contract laws in Asia are like in Europe. But if we look at the examples I've just given you, they're more at the structural level. So, is contractual interpretation subjective or objective? Overarching question. What are the aids to interpretation? What do we do for gap filling? But if we dig a little bit deeper, even below the structural issues of an individual doctrine, then we see the nuances. So we see, for example, what I call rejected transfers. Good example if you go to India. English law has a so-called plain meaning rule in contract that was particularly strong in the 19th century, has since been softened, which addresses this question of literalism versus contextualism. If the text of the contract is clear and unambiguous, you have to follow the text, even if the outcome is utterly absurd and you can be sure that the parties didn't intend it. Plain meaning rule, you look at the words, full stop. That probably made sense in England in the 1870s, in a relatively small, homogeneous and monolingual jurisdiction. You go to India, 3,000 languages, even then, more than 100 million inhabitants, by today 1 billion. It doesn't work. You never have a plain meaning. So in Indian contract law, from the beginning, no one tried to transfer the plain meaning rule. Similarly, Indian law did not adopt the exclusionary rule that excludes recourse to prior negotiations in the interpretation of the contract. Another rejected transfer is a little bit more recent, and it shows us also the dynamic between what we might call the mothership, in this case England, and the satellites, in this case Hong Kong, Singapore, and Malaysia. In, can't remember, Attorney General versus Belize, 2002, maybe, beginning of the millennium, Lord Hoffman, one of the more prominent judges in the House of Lords, decided that this idea of implying terms and having that separated from interpretation for gap filling, he thought that was not a good idea, and probably without knowing, suggested a kind of continental approach and saying interpretation and implication of terms are more or less two coins of the same medal. It's a single doctrine. That was not received with great enthusiasm by my more conservative contract law colleagues in the UK, but if the House of Lords says so, then that is your contract law. But Singapore and Malaysia refused. They didn't go along, and they said so. Their Supreme Court said so, quite openly, said, no, I mean, that English law did this, or has recently done this, does not affect us. We're basically staying more English than the mothership. And, interestingly, the UK Supreme Court has since backtracked and said, well, Hoffman had a sort of a weak moment when he was uttering this, and we're putting this to one side. But you also have what I call sticky transfers. So the Hong Kong Final Court of Appeal actually went along with Lord Hoffman in this case and said, yeah, it would be a good idea to have a kind of single doctrine of interpretation and implication. And when the UK Supreme Court rolled back, the Hong Kong First Court of Appeal said, no, I think we'll stick to our guns here, so we will also in the future go along with the new English approach that has still been, has yet been discarded. Then you have a phenomenon that I call irrepressible transfers. Because these, in the jurisdictions that adopted a European code, the codifiers were often very careful in what they actually introduced and what they left out. And again, from the interpretation of contracts, a good example is the Civil Code of Taiwan. That adopts only one of the two provisions in the German Civil Code on contractual interpretation, and deliberately didn't adopt the second, which basically says contracts must be interpreted in good faith and with regard to the usages of trade. Interestingly, the courts simply adopted this rule and read it into the Taiwanese Civil Code, although the legislator had deliberately left it out. Then what we see are what I call localized transfers, transfers that are where the English, French, or German law is implemented, but is adapted, we wouldn't even say to the local circumstances, but to the local preferences of the courts. One example would be the role of good faith. That is much more expansive in Taiwan and Korea than it is in the German interpretation of contracts. Another example is the doctrine of implication of terms for gap filling that I've mentioned. That is already very narrow in England, and the courts in Singapore and Malaysia have made it even narrower to make it even more difficult to imply a term. So what we have is what we might say a transfer, but the outcome in an individual case may be very different. My second example, and I'll be much faster now, is the policing of unfair terms. Again, if we look at the structural level, we see huge similarities, because you can have different justifications for controlling unfair terms. You could say, well, this is a question of consumer protection, the French approach. You could say, this is a protection against certain types of clauses that are particularly prone to be harmful, like exclusion of liability clauses, that's the English approach. Or you can say, well, this is a protection against the use of standard terms, generalized terms, that businesses tend to use in order to push their unfair regulations of contracts into individual contracts. These are different that's the German model. These are different starting points, although they very often coincide, because standard terms are also used in consumer contracts, and these standard terms can also include exclusion clauses, but the starting point is a different one. And again, these justifications or ideologies of protection against unfair terms map in the Asian jurisdictions more or less one-on-one on the European models. Where we see much bigger variation is in what contract lawyers who work in this field often call the flanking measures to protect against unfair terms. What are the procedures that you develop? Which are the agencies that control the terms? Should this actually be done by the courts, or should this be done by an administrative agency? Should this be done perhaps in an expedited procedure? Should this be done in a special court? And there, all of a sudden, we see huge variations, very different models, and they have nothing to do, absolutely nothing to do with the kind of genealogy that we see in substantive law. Again, we can see interesting examples of sticky transfers where the emulators stick to the old law while the mother jurisdiction moves on. English law, for example, in this field has this, or used to have this, distinction between different types of terms: warranties, conditions, and innominate terms. Totally incomprehensible for someone who did not read law in England in the 1950s, but that was a big thing. And the Malaysian lawyers continue this. It has no basis in the Malaysian Contracts Act, which is, as we have learned, based on the Indian Contract Act, but it was imported at some stage, and this is what is going what is going to be continued. Or you have, again, what I call localized transfers, where a transfer is actually made, but it's modified. Hong Kong adopted the Unfair Contract Terms Act 1977 that has this policy of singling out different types of clause, liability clause, exclusion clause, and saying these are particularly harmful, potentially harmful, we have to monitor those closely, and there are some tools to do that. And Hong Kong adopted that statute almost word by word, but it actually added a factor. It said that in assessing whether a term would be unfair or not, one of the factors that should be considered by the courts is the linguistic capacities of the parties. So again, we see this is a multi-linguistic jurisdiction, Mandarin, Cantonese, English. People often speak only one of the three, and this should be, this was implemented by the legislature. Now, I could go on and on and on, and I could talk about invalidity, but we're all hungry and thirsty, and that includes me. So I will just skip my third example, and I could give you many more examples from other volumes. I was stunned to learn that the Taiwanese legislator implemented in 1960 a doctrine that the German courts had developed after hyperinflation, so-called Wegfall der Geschäftsgrundlage, the collapse of the basis of the transaction. In Germany itself, this was only codified in 2002. But it was so strongly present in Taiwanese legal scholarship, because all these professors had done their doctorate in Munich and Heidelberg and elsewhere, that they pushed the Taiwanese legislator to adopt this in the 1960s. So plenty of examples across all the areas of contract. Now, why is it important that we know these things? Why do we have to go back to the European legal past in building the future of Asian contract laws? The future is built in these Asian jurisdictions at two levels, at the moment really only at one level, and that is constant law reform. I already told you that in Vietnam, 3 civil codes, and these are massive civil codes, and 3 very different civil codes were adopted within the space of just 20 years. The Chinese Civil Code, a massive project of reform, was just enacted, and all these jurisdictions have constant law reform projects. And I think for those it's important to know where we come from if we want to go in the right direction, not in the sense that we should advise these countries and our colleagues there that they should stick to their model, but because of the risk of very strong inconsistencies once you start bricolaging. And that's what you can see in Vietnam, where all these influences are interjected from different positions in the legislative procedure, and then you end up with a civil code that in many, and I'm only speaking here on behalf of my Vietnamese colleagues, not that I could read Vietnamese, but that in many areas simply do not make sense. So we need to know the general structure and where it comes from if we want to reform individual rules, doctrines, and institutions. The second level where law reform happens in those countries, and this is still very much at the beginning, is a reform project that is modeled again on a European reform project, namely the principles of European contract law that many of you in this room will be familiar with. There was an initiative to adopt something similar with an Asian flavor, principles of Asian contract law, but this project has not been successful. And this brings me back to the beginning of my lecture. Why has this not been successful? Think back to 1989. We might say that European legal history, perhaps even comparative legal history, has a really modest role in securing peace. That sounds a little bit grand, I know. But if you compare the process of European integration, and that includes European legal integration and the integration of European scholarship, of which this society is a model example. If you compare that with Asia, you will see that there is a true difference. And that was, for me, at the personal level, perhaps the most striking takeaway point from this project. In East Asia, you didn't have similar reconciliation efforts as we saw them in Europe. Korea and China still resent Japan. Everyone is afraid and distrustful of mainland China. We don't even have to mention Taiwan. So an economic and legal integration, as we have become accustomed to in Europe, is still very much in the future and very difficult. And so I would like to congratulate this society for being better and being forward-looking and being an important part of European integration, including legal integration. I wish you all a great conference, and I wish the society an utmost success. Thank you very much.
Thank you very much, Professor Vogenauer. I think we just heard a masterclass in the tension that is inherent in comparative legal history, which is on one hand focusing on similarities and then focusing on differences, but then looking onto the historical origins of what these might be, and then turning that into some prescriptive projects and looking towards the future. So thank you very much. In the interest of feeding our speaker and the general conviviality of this dinner, there will not be a Q&A session. If you have questions about his speech, I will certainly be asking some, abusing my privilege of sitting next to him. But please approach Professor Vogenauer over the course of the dinner, and I'm sure that we will have some fruitful discussions here. So, with that, I will end my duty as chair of this keynote speech. Thank you very much.
Now I invite the Rector of University of Szeged, Professor László Rubó, to welcome the participants of the gala dinner of the 8th Biennial Conference of the European Society for Comparative Legal History.
Ladies and gentlemen, dear distinguished guests, it's a really great privilege for our university that you are here. So, this congress is about the legal history, and Szeged is also a historical city. It was mentioned first by Ptolemy, and I think it was a really long time ago. And our university is also quite old, because the 444 year was the establishing of this university in Kolozsvár, Hungary. It was 444 years ago. So we are proud of our university, because now it's among the best universities in Hungary, and we are very good at rankings, the international rankings. And to be honest, I think we are most famous in the biological and medical fields, because we have two Nobel laureates here in Szeged, but we are very proud of the more than 150-year-old legal faculty, with so iconic members of the legal history as Eleanor Balogh and I here in Hungary. So I'm very proud of him. So I don't want to speak too long, because the good welcoming speech is short, and I wish you a very good conference, a very good dinner. I'm pretty sure it will be, and I wish you a very good conversations. So thank you very much for that you are here.
Now I invite the Chancellor of the University of Szeged, Dr. Judith Fendler, to deliver her welcome speech.
Ladies and gentlemen, dear guests, it is both a great pleasure and an honor for me to offer this toast, probably later on the occasion of tonight's gala dinner, not only on behalf of our institution, but also on behalf of our city. I believe the University of Szeged has reached yet another significant milestone. We are proud to serve as the latest host in a distinguished conference series that has toured some of Europe's leading intellectual centers, from Valencia through Amsterdam, Macareta, Nantes, Paris, and Lisbon, all the way to the most recent gathering held in Augsburg in 223. And now, I'm pleased to say, the baton has been passed to Szeged. Our gathering here this evening and the opportunity to welcome you as our guests, it is a testament to the spirit of openness that increasingly defines our university. We are deeply committed to professional collaboration. That is why in recent years we have made significant strides in expanding our international network. However, these partnerships serve not only as a foundation for joint research and educational projects, but also as means of building value-driven communities. Communities grounded in shared scientific goals and collegial relationships. This event, in particular, holds special significance. It is always a pleasure to host conferences dedicated to uncovering the past and bringing its insights into the present. That focus resonates deeply with our institution, as our predecessor in Kolozsvár, as the rector mentioned, and places us within a higher education tradition that spans nearly 5 centuries. We firmly believe that we can only face the challenges of the present effectively if we understand the past. Indeed, legal history research based on primary sources plays a crucial role in this regard. It not only holds up a mirror to us, but also offers guidance for the road ahead. Last, but certainly not least, allow me to express as how proud we are of the university's Faculty of Law and Political Science. It is one of our most accomplished academic units and a truly fitting host of this event. It fully deserves to be in the spotlight of the international legal scholarly community once again. At this point, I would like to extend my heartfelt thanks to all our colleagues whose dedicated work made this conference possible and to play a key role in this smooth execution. I'm equally grateful to our distinguished guests for accepting our invitation and for contributing to the success of the conference through their presence, outstanding presentation, and valuable professional reflections. Ladies and gentlemen, as a gesture of respect, both on behalf of the University of Szeged and personally, I raise, thank you very much, I raise my glass to all participants of this event, to the freedom of science, to professional collaboration, and to the future we are building together. Thank you very much for your presence.
Thank you for the welcome speeches. We have reached the end of the official part of the gala dinner. We sincerely thank you for your attention. We are delighted to have the musical accompaniment for today's event provided by the Lumen Quartet, which is a string quartet from students of Bartók Béla Faculty of Arts, University of Szeged. The title of their musical performance is Classical Selection with Hungarian Thrones. We would like to express our sincere thanks to the sponsor of the gala dinner, Bodri Winery, for their generous support. The dinner this evening will be held until 11 p.m., after which we will need to leave the building. We wish everyone an enjoyable time. Thank you.